5 immigration changes every U.S. visa holder must know. The rules are shifting quietly but powerfully. Right now, the immigration system is moving faster than most people realize. Between mid-June and mid-August, 5 major changes have landed, and they're already in effect. These aren't proposals. They're not coming soon rules. They're here, and they can derail your application, threaten your status, or block your family's future without warning. Some will hit your wallet. Others will hit your timeline. One could even shut down your eligibility overnight. Let's break each one down in plain language so you know exactly what happened, when it happened, and how it could directly impact you. 1. The filing fee hike that can end your case before it starts. On July 22nd, USCIS raised filing fees for multiple immigration applications. This wasn't a minor increase. It was a hard reset tied to provisions inside H.R. 1. For months, applicants hoped for a grace period. Instead, USCIS went straight to full enforcement. If your package is postmarked after July 22nd, you must pay the new fee, no exceptions. The danger escalates on August 21st. From that date forward, any application sent with the old fee will be rejected instantly. No courtesy letter. No second chance to correct it. That means your entire application, no matter how perfect, can bounce back over a missing $20, $50, or $200. And by the time you resubmit, deadlines or visa caps may have passed. If you haven't filed yet, confirm your exact updated fee directly on the USCIS website. Double-check your payment amount before mailing or submitting anything online. Right now, even a small payment error can kill your case instantly. 2. Family-based green card denials without warning. As of August 1st, USCIS officers now have full discretion to deny family-based petitions without first issuing a request for evidence, RFE, or a notice of intent to deny an OID. In the past, if you missed a key document, like a birth certificate, joint lease, or tax transcript, you'd usually get an RFE. You could fix it and keep your case alive. Not anymore. Now, if the officer decides your file is incomplete or unconvincing, they can close it on the spot. The ripple effect is huge. A denial not only forces you to start over, it can also trigger removal proceedings if your current visa or status expires during the process. Immigration attorneys are already seeing real denials for gaps that, a year ago, would have been easy to fix. That's why your first submission must now be your strongest submission. If you're filing a family-based case, include every possible piece of evidence up front. Anticipate every question the officer might ask. Treat it as a one-shot deal, because that's exactly what it is. 3. The CSBA change that could age out your child. For years, the Child Status Protection Act, CSPA, helped families keep kids eligible for green cards even if the process dragged on past their 21st birthday. Previously, age was calculated using the dates for a filing chart, the FASTER chart. That meant many kids, especially those from H-1B families, stayed locked in as dependents. On August 15th, that changed. USCIS will now calculate age using the slower final action date chart. For families from India, the impact is devastating. The EB-2 and EB-3 backlogs mean the final action date can lag years behind, and some kids will now age out before their green card becomes available. Once a child ages out, they lose derivative eligibility. They must start from scratch with their own independent application, which can take years or be impossible entirely. There's a limited transition period until the end of 2025, but it's only a temporary cushion. If your child is nearing 21, review your timeline now with an immigration lawyer who understands every detail of CSPA. 4. H-1B layoffs and the grace period crackdown. The 60-day grace period after losing your H-1B job has always been a safety net. It gave time to find a new employer, change status, or plan departure without falling out of legal status. But recently, some H-1B holders have received notices to appear, NTA, in immigration court during that grace period, as if they were already overstaying. That's a dangerous contradiction. On paper, the 60 days still exist. In practice, some officers are treating it as if it doesn't. Once an NTA is issued, your record changes. It can impact future visa approvals, green card eligibility, and even your ability to re-enter the US after leaving. If you're laid off, don't wait 60 days. Act in the first days. Start your job search immediately. Consider a quick status change filing. Keep every email, letter, and record as proof of your efforts. In this climate, the grace period is no longer a guarantee. It's a race against the clock. 5. The Visa Bulletin filing date shift. Every month, the Visa Bulletin sets 2 dates. Final action date. A dates for filing, which chart USCIS uses can make or break when you file your adjustment of status. In July and August, subtle but crucial changes in how USCIS aligns with the Department of State have caused delays. Applicants expecting to file under dates for filing discovered USCIS was using final action dates instead. That difference can push your filing window months, even years, into the future. It's technical, but the impact is real. Filing early lets you get work permits and travel authorization while you wait. Filing late means waiting longer for everything. Never assume USCIS will follow the same chart as last month. Always check the USCIS monthly adjustment filing page before making any move. One chart change can shift your entire immigration timeline. Conclusion: 5 changes. 5 new ways your application can stall, shift, or collapse, and all within the last 8 weeks. From fee hikes to same-day denials, from children aging out to grace period crackdowns, the system is moving fast, and it's far less forgiving than before. If you remember nothing else, remember this. Every filing now needs to be perfect on the first try. Every timeline must be double-checked. Every risk should be addressed before it becomes a crisis. The U.S. immigration process has always been complex. Right now, it's also unpredictable. And staying informed is your best defense. If you like this video, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching. See you in the next video.